Okay, so we're starting off talking about law and ethics, going into HIPAA. So there's a few things we'll talk about. The privacy rule is the biggest one, and then security and transaction rules. Important to know for the test, any significant electronic communication with the patient will then put you under HIPAA laws. Overview of the main points. So on the exam, they might ask if you need a digital signature, and there is nothing that says that. You will just need to document consent. So what exactly is HIPAA? This is federal law to protect Americans from losing health insurance, designed to streamline the healthcare system by creating standards for uniform transmission of electronic healthcare claims. It requires standards for storage of patient information and protecting privacy rights. There are 3 rules to HIPAA. The privacy rule regulates and safeguards regarding confidential patient information. The transaction rule standardized electronic transmissions. And the security rule addresses physical security of patient records, like locking filing cabinets. When it comes to HIPAA or state law, whatever provides either greater privacy protection or to the client or greater access to the client for their health information. Who must comply? Well, you can look at this chart, but the moral of the story is if they are a healthcare provider that uses electronic communication. Protected health information. We need to distinguish between that and psychotherapy notes. PHI is something that identifies a patient. It's transmitted in any form, and it includes their condition, their services, and their payments. Some examples of what would make something PHI. And then what about the privacy rule? This is the big one. This is what protects their information. It requires providers to inform them of their policies, grant clients access, obtain authorizations before sharing non-routinely, securing their records, informing business associates of privacy practices, and training employees about privacy procedures as well. So what about accessing your healthcare information? Well, you as a client, you have the right to have access to it yourself. And if you are denied, there's 2 different standards with HIPAA and California law. HIPAA says that you have a right to review the denial if they denied it because it said it was reasonably likely to endanger the life or physical safety of someone. However, they say they don't have the right if it's because it's something that's exempt from right of access, like it's compiled for use in a criminal case. HIPAA permits but does not require them to maintain their 2 sets of records. With HIPAA, clients don't have the right to review therapy notes, but California law rules here, and psychologists may, upon request, provide the client with a copy of their notes. Authorization to disclose. There's 2 things, generalized consent and authorization. Generalized consent is basically anything of what they call TPO, is you don't need to actually get formal consent if it's in the for the purpose of treatment, payment, or healthcare operations. However, information released to anyone that is not related to their healthcare, like an employer or school, does need their consent. Clients have a right to the notice of privacy practices and to have it explained to them in reasonably understandable language. What are the minimum necessary standards? And finally, what about patient rights that are in HIPAA? You have right of notice, knowing the privacy policy, right to request restrictions of use of your information, right to get information with phone calls and bills and to whatever address you want, have right to inspect your records unless it would jeopardize someone's safety, right to request changes to your record. Of course, you can say no if they're asking you to say something inaccurate, and then right to receive an accounting of everything over the past 6 years. And what about the security and transaction rules? These are going over electronic transmission safety and the security of patient files. Okay, competence is also important. Psychologists are legally and ethically obligated to practice within the scope of their competence. We'll talk about that in terms of unprofessional conduct, emergencies, personal problems, delegating work to others, and also what happens when you want to explore a new kind of area. Okay, so California Code 1396 says a psychologist shall not function outside their particular field of competence as established by their education, training, and experience. Further, the board may refuse to issue any registration or license or can suspend or revoke if they found a person has been guilty of unprofessional conduct. So there's the California Code and Board. In terms of the Ethics Code, ethically you must provide services only within boundaries of competence. If there's an emergency, you can provide services until someone else shows up who is more competent and the emergency is over, or the emergency was over. Finally, we are legally and ethically obligated to take appropriate actions when personal problems might interfere with the ability to provide effective services. A couple other notes about boundaries of competence. If you delegate work to other people, you are still obligated to that they are able to perform the duties competently and make sure there are no harmful multiple relationships there. And if you want to go into a new area of your practice, you actually are allowed to do that, but it's important that you consult, get further training. You have to get new supervision for something completely outside. But if you have close and no one else in the town can provide those services, then you can get some more training experience and consult and provide them. All right, moving on to the discussion of confidentiality and privilege. We're going to talk both about the ethical and legal requirements as well as defining our terms. So let's start with confidentiality. This is the obligation of their psychologists to protect their clients from unauthorized disclosures of information that was revealed in the professional relationship. Remember that we must give this confidentiality to the public as well. We consider them as well as our patients. So what are the legal requirements in terms of confidentiality? We need to know about the Lanterman Petra Short Act and the Confidentiality of Medical Information Act, which basically say client information is confidential and there's specific circumstances you can release it. Here are the different codes. Okay, so now let's talk about when we can breach confidentiality. In situations of threat of serious physical violence, if the client, it's a 1024, if you have reasonable belief that a client is a danger to themselves. If the minor is abused and elder is abused, if a court orders it, and the Patriot Act finally as well. Okay, so privilege is a legal term, and this refers to the person's right not to have confidential information revealed in a legal proceeding. The holder of the privilege is the patient when they have no guardian or conservator. It can also be the guardian, or if they're dead, a personal representative that's been appointed. And let's talk about the exceptions to privilege. Privilege does not apply, of course, when the client authorizes a release of information or when the psychologist is legally mandated, for example, abuse. Again, as well, the client, if they disclose a significant part of the information to a third party, it's no longer privileged information that the therapist can't discuss. And finally, there are some legally defined exceptions, and there are 9 of those. Someone's in a court case raising the concern of an emotional condition, they open up their file. If the therapist is appointed by the court to evaluate, there isn't privilege, but you need to let the defendant know that. The Board of Prison Terms might appoint someone to evaluate if they need mental health treatment. Again, there's no privilege there, but you want to let them know. Crime or tort. Now, if a client runs into your office to try to escape the police, you're aiding them in committing a crime, and you are not required to there is no privilege there. It's not even about holding privilege. There's no privilege then. Breach of duty out of the relationship, no privilege. No privilege with determining sanity of a defendant. No privilege when someone is a danger to themselves or others. That's 1024, not terror-soft, 1024. And finally, 2 more things. If it's a proceeding to establish their competence, or if they are under 16 and they were a victim of crime, there's no privilege there, though it doesn't have to be reported. It's up to what's the best interest of the client. So these are the different so 3 different people can hold privilege. With minors, it's a little bit of a complicated issue because according to kind of in the country, it's the guardians considered the holders. But in California, we say that minors themselves have privilege, but even though the adults will typically claim or waive it for them. Parents don't have access with emancipated minors, of course. And if you're a ward of the state and you're over 12 and mature, then the kid has the privileges for sure. Who has the privilege? Basically, the client. And if there's a couple, they're both the client, so they both have it. So here's a list of the exceptions to privilege in a little bit more detail. The exceptions to privilege codes are 1016 through 1027. If a client is suing an airline company, for example, for emotional distress, that opens them up to their therapy records becoming completely public. You must tell someone when you're determining their competence or sanity that they don't have any confidentiality, so that has to be clear. Board of Prison Terms, that would be just about, do they need treatment? And actually, if we are a victim of crime, we may also break, in this case, we can break confidentiality. So that's actually about confidentiality, not privilege, but we can break it in that circumstance. All right, we're going to talk about legal and ethical decision-making, particularly management issues in therapy. You're required to give both the notice to consumers and the notice of privacy practices to your clients. Well, actually, notice to consumers just needs to be hung, and privacy practice must be given to them and placed prominently. So what about informed consent? This is addressed predominantly in the ethical standards, with one exception being the telehealth. And you will find this in the ethics code primarily. So when you want to provide informed consent, for informed consent is what it is if it's someone who's capable of understanding. If they're a minor or they can't understand, you can seek assent, which is a little bit different. What are the conditions for informed consent? There must be the capacity to make rational decisions, the comprehension, so you need to provide reasonably understandable language, and voluntariness. They cannot be coerced. So the only legal requirement to really know about is that for telehealth, which is when it's delivered via technology, there needs to be verbal consent, and you need to document that. So the ethics codes that address this are 310, 1001, and 903. So we'll talk a little bit more about that. For people who are legally incapable, seek their assent. If you're conducting any sort of research or assessment therapy, any professional activity, you must obtain informed consent unless there's a mandation, you're mandated by law or regulation. Not that you don't need to or shouldn't. Court-ordered services must provide informed consent. Inform them. I mean, they can't. It's kind of court ordered, but they must be explained the limits of confidentiality, and just always make sure that you document it, no matter what. This should be in the file. In terms of third-party requests for services, this might have to do with parents and kids or court-ordered evaluations. Need to be really clear of who the client is, even if there's not a simple answer, and clarify these things with the different parties. What are the confidentiality limits? Like with an employer, you need to say, hey, I'll give you the information that's relevant to the evaluation, but not all of the information is open to you, like about their marriage or something. We'll talk about client records, both in terms of how they must be maintained and when and how clients can have access. So who owns the record of a client? Well, actually, the client is the one who owns it. However, the psychologist owns the physical or electronic document. We are responsible ethically for maintaining records. This is addressed in number 601. This is also true with research studies. We must also maintain confidentiality of these records and dispose of them properly, as well as plan on what to do if we ever die. We need to have a plan in place. How long do you need to keep the records? Well, California law preempts HIPAA here because after a minor turns 18, it must be for 7 years after that. And what about the electronic record keeping aspect? We must ensure safety and integrity as much as if it was a hard copy, which means offsite backup, image mechanism to copy signature documents, making sure things are unalterable. And once something's electronic, you may destroy the hard copy. Most important here is the client has access to records. Of course, there's always exceptions. And those exceptions are different when it comes to HIPAA and California law. In some cases, HIPAA preempts, in some cases, California does. So similar to HIPAA's privacy rule, California laws are pretty similar to this. So let's see. Let's first talk about when you can deny a client. Okay, when can you deny a client? Well, when having access would reasonably be likely to endanger the life or physical safety of the client or another person. That's HIPAA. However, in California, it doesn't have to be that extreme. It's that there's a substantial risk of adverse consequences. Now, so in this case, you have to follow HIPAA because this gives the client more access. In terms of psychotherapy notes, California wins because while HIPAA says you absolutely can't have access to your psychotherapy notes, California says actually you may give them a summary or the actual note if you want. In California, it says you have to present healthcare providers with a written request for records, which is consistent with HIPAA as long as clients are informed of this. And finally, can you withhold records because of unpaid bills? No. So what happens when a client requests the record? Well, there's a time frame for responding, and that's important to be aware of. If you have a longer record, it can be extended to a month. And there's different time frames, whether it's being copied or summarized. Okay, so we're going to talk about multiple relationships and conflicts of interest. So let's define a multiple relationship. Well, multiple relationship is basically saying that you are in two roles with a person. It might be with that person specifically. You could be in a relationship with someone closely related to them, or promising to enter a future relationship. All of these three things. Multiple relationships are addressed in the ethics code. So this isn't a legal issue in particular as much as it is an ethical issue. Multiple relationships are not inherently unethical. There's two conditions to meet for them to be acceptable. They must not impair objectivity, competence, or effectiveness, and they must not harm or exploit the other party. If something does occur and a multiple relationship arises, it is the psychologist's duty to resolve it with due regard for the best interests of the affected person and maximal compliance with the ethics code. So that is what you are supposed to do. Here's more on multiple relationships. Just to be careful and mostly just no harm. What about forensic settings? There's two things to consider here. The first is if you're legally required to do it, if it's not avoidable, make sure you clarify role expectations and any confidentiality issues. Now, secondly, let's say that you've been asked to, then try not to, but make reasonable efforts to refer. But if that's not feasible, you can do it. Just disclose risk, consider risks and benefits of all parties, and basically you're just trying to minimize any negative effects of the circumstance. A little more on forensic psychology. Multiple relationships do come up, so really trying not to provide concurrent services, but if you do, you do. Conflict of interest. Most importantly, you don't want multiple relationships to bring up a conflict of interest. So if you're teaching and you're grading and you're the person's therapist, it presents a conflict of interest. Gottlieb recommends the 3 different aspects to multiple relationships and how to determine if it's not ethical. If it's long, if there's a strong power differential, and how far in the past that relationship really is. Is it really not therapeutic anymore? It's fees and financial relationships, important to think about referrals, bartering, and ethical guidelines. Most important is that you need to set your fee as early as feasible. You are not to misrepresent them. It must be consistent with law. And you need to discuss any limitations of services that could happen if they can't pay. If you want to use a collection agency, you are allowed to do so, but you must notify the client and give them a chance to pay it before calling the collection agency. You are not obligated to keep working with someone, but terminate ethically and appropriately if they can't pay. You don't have to. You can see them free if you want, which leads us to General Principle B, which is you are encouraged to offer pro bono services, but not required. Bartering is also addressed. As long as it's not clinically contraindicated and it's not exploitative, it's okay. Referral fees are a huge no-no. If someone refers you and you're splitting a fee in terms of services that are actually provided, like you pay them for the assessment they did for that client, that is fine, but it cannot be based on the referral itself. Referrals and fees. What else? When it comes to insurance companies, this is a big deal, actually. Insurance fraud is both illegal and unethical, and you should know that for the exam. Insurance fraud could constitute routinely waiving co-payments, billing for missed appointments without the insurance company knowing, and assigning an incorrect diagnosis. Again, set the fee as soon as possible. And a little more on insurance, limits on treatment and fraud. So those are 3 ways that you can be committing insurance fraud. A lot of people are doing it without realizing. You need to also be really accurate about what services you're actually providing. And what about the limitations? They can deny treatment. So this is something that could happen and you need to be able to work with. If they don't authorize payment, what's the first thing you want to do? Appeal it. If that's denied, then you can discuss with your client an alternative payment method and try to work something out. Talk about the ethics code. a little bit more. It is important to make reasonable efforts to plan for facilitating transfer of services in the event that something is interrupts it, like illness, death, or anything like that. Termination of therapy. If a client doesn't need the services, isn't benefiting, or is being harmed, terminate. You can also terminate when your life is in danger, whether it's because of the client themselves or somebody related to the client. And except where precluded by clients and third parties prior to termination, you need to provide pre-termination counseling and suggest alternative services. What about relating with other professionals? We're going to talk about both cooperation and when your client's seeing another professional. So cooperating with other professionals is really important to the practice, and confidentiality becomes an issue. So don't disclose anything that could lead to their identification unless you have prior consent, and only disclose to the extent necessary for the actual purpose of the consultation. If a client is receiving services from another professional, proceed with caution and sensitivity to the therapeutic issues. That's the quote. Carefully consider the treatment issues. So if it's something that is markedly different, if they do CBT for tobacco cessation and you are a psychodynamic, that's probably okay. What about advertising? With regard to advertising, a few things you want to know about, and it's basically you want to be clear, you want to be honest. Professional identification. So you need to be very clear about who you are, and there's California codes and laws about this. You need to include your license number, any professional activity. Don't misrepresent your qualifications. That could be your degree, your institution, your training, your competence, anything. And if you do, you can have your license either revoked or suspended, or so especially if it is willful. California law covers these things, and it talks about, so CCR 1397 with advertising. This is interesting because it says advertising can't promote excessive or unnecessary use of services. So everybody should have CBT. No, you can't do that. And they don't want you to say anything is based on fact or evidence. So no therapy advertisements can compare to another product, say it's based on evidence or anything like that. What else? If you change your workshop, you need to do it for a description of your workshop. You need to do so for a reason. If it's a class, let the class know along the way with reasonable time to adjust. Soliciting business. You cannot, well, the ethics code says you can't have in-person solicitation, or actually standard 506, no in-person solicitation uninvited if you're not invited. And in particular, if it's people that are your therapy clients and vulnerable to undue influence. But there's two things you can do. You can bring people in for the purpose of helping your client if you need their wife to come in, or if you're providing disaster or community outreach services. So here are the standards. Avoiding false deceptive statements. You can't compensate others for advertising for you. You can ask people for testimonials, but not current clients or vulnerable clients. And finally, when you're giving a media presentation, you just want to be really careful and be very clear that there's no relationship established. So you're basing things on information, you're not giving advice. Okay, now we're getting into treatment of minors. Treatment of minors is a tricky business. We're going to talk about consent and access to records. Consent to treatment by emancipated minors. First of all, an emancipated minor is considered an adult for the purpose of health care and can do things without parental consent. There are three situations for emancipation. marrying legally, enlisting in the military, or court declaration. The court declaration requires that they're 14, living separately, the parents agree, they can take care of their own finances, and they do not get their money from crime. So what does the California Code say? Yep, they are an adult for the purpose of psychiatric care, but it doesn't change things like driving, drinking, voting, and rape. Okay, well, what about not emancipated minors? This gets really kind of tricky, and yet it's actually very simple. First of all, you have to distinguish between, this is really about, can they consent to be treated without their parents' consent, and what about the parents' access to their records? So in terms of consenting to treatment, you need to consider first whether it's just an outpatient facility, and secondly, whether this is a more kind of serious setting, a runaway house, inpatient setting, or Medi-Cal is covering it. Now, if it's outpatient, it's a little less stringent. They need to be, the professional needs to believe they're mature enough to participate intelligently. They shall include the involvement of the minor's parent or guardian unless they think that it would be inappropriate. If the minor is consenting, their guardian's not liable for payment, and this does not apply to minors, who receive Medi-Cal, like we just said. So 12 years old is an important number to remember with these. If, however, they want to get services at an inpatient facility, not only do they have to be able to participate intelligently, as before, but in this case, there really needs to be a serious threat associated. Not just, it would be inappropriate. This is, alleged victim of incest or child abuse, or they could be seriously physically or mentally harmed without services. Anything else to know? Well, they can receive treatment for drug and alcohol-related problems under California Family Code after age 12, and you must try to document the guardians. And if you decide not to, you need to document exactly why. They cannot receive methadone or other replacement narcotics, however, without parental consent. So, treating a minor without parental consent, here's your 3 things to always remember. They have to be mature enough, there must be a rationale, and you need to put in your notes why. Talking about minors, we will talk more about different ages, but 12 is the earliest that a kid can be seen without consent of parents, and 14 is the earliest that they can be emancipated. 18, of course, is adult, and then 16 will be more pertinent when we talk about sexual abuse reporting. And just, remember, you can't give them narcotic treatment without consent, even if they're legally consented to everything else. What about these not emancipated minors that we were talking about? So not most minors are not. So what about them? Well, they have a right to their own records, but so do their parents. And however, if there would be a detrimental effect on the relationship, or if there's physical or psychological well-being in jeopardy, the provider can deny permission to the parents. And they have to put that in writing, and they need to also permit inspection by another professional to kind of confirm that that's actually fair. And this is actually consistent with HIPAA. Who has access to records? Basically guardians. And if, even if someone's not in physical custody, they still have their rights. And words of the court are called 300s, and the court is the one who kind of plays the role of guardian, but often they will have a social worker or someone that they kind of send to act on behalf of the court. Okay, now we're getting into the world of clients that are a danger to self and others. We're going to talk about Tarasoff, duty to warn, as well as involuntarily committing someone. Different laws that are important to know in regards to this, most importantly Tarasoff and Ewing, but also CMIA, when does it not apply, and also what about HIV? So the Tarasoff case, this woman was in Europe, and Tarasoff said, or this guy named Podar said, I'm going to kill her. The therapist went to the police and his supervisor. The supervisor was mad that he did it. Nobody did anything. Podar killed Tatiana when she came back, and the Supreme Court ended up saying that you do need, the therapist did the right thing, but you also need to warn the victim. So he was actually in trouble for not warning her. So the Tarasoff decision is two things. Is the client readily identifiable, and is there a serious threat of physical violence? If those are both there is the duty to warn and protect. And you need to go to both the police and the victim themselves. And another thing to know is the client has to tell you about this. It cannot be, well, it can be someone else, but we'll go into that. So the client tells you about somebody else, they're going to go kill this person? Nope, can't break confidentiality there. Now, Ewing expanded it to say, hey, if somebody's wife calls and says he's about to kill XYZ and he is your client, this is a case in which if there is a threat of grave bodily injury, the duty to warn can be triggered. The confidentiality, this act, well, we've got two things. One, we've got the 1024 and then the CC 5610. You can disclose, so this is different. So even though you cannot invoke Tarasoff if your client says, hey, this guy I know is going to kill him, what you can do is you can invoke section 5610, where you can disclose something if you really believe that doing so will lessen a real threat to a person or property. When does it not apply? If it's not the client, so we're talking about Tarasoff again. Tarasoff does not apply to other people being the dangerous party other than the family member if there's no reasonably identifiable victim, or if they're threatening suicide. That's a different case. So suicide, that's a 1024. It is never a Tarasoff or duty to warn. HIV, and you're getting into a little bit more of a complicated territory, and this is a gray area. Basically, in California, physicians are protected if they disclose, but there is no protection for psychotherapists if they're disclosing HIV status. You really aren't supposed to breach confidentiality in the state of California here, but if you think that they're in a manic episode and they're HIV positive and sleeping with 40 people, in that case you probably want to say they're a danger to others due to a mental disorder. So then you can involuntarily hospitalize them, which is not Tarasoff, but it is one way to protect everyone. So 1024, this is kind of your Tarasoff alternative, because suicide is never a duty to warn. In fact, you're not legally required to do anything, but you might be sued for malpractice in the ethics code. You can get in real trouble if you're not doing what you should be doing professionally. 1024 can be applied whenever you think there's danger, basically. Not as kind of casually as I just made it sound. But the thing about 1024 as opposed to Tarasoff is you don't have coverage or money to protect you, like where Tarasoff there is. The client can sue you if you break privilege here. Involuntary commitment. Okay, now we're getting into the different kinds of holds and the different reasons. So it could be danger to self, others, or grave disability. In addition to these conditions, it needs to be because of a mental disorder or chronic alcoholism. And if the client has refused to comply with the recommendation, then it can be involuntary, but certainly give them the chance to go voluntarily. So here's the codes in California. 5150, you have no rights. And it's important to remember this is actually, 5150 is actually for adults, 5585 is for kids, and we'll talk more about that. But at this point, you have no rights. But once you get into 5250, which is the 14-day hold, now you're believed to still be a danger, but your rights, now you can file a writ of habeas corpus. You start to have legal rights. And post-certification, there's a split now between the different reasons you're being held, and different laws apply. So with a 5150, you need to specify why. 5230 is for just alcohol and drug use. Grave disability, can't care for self. It cannot be an intellectual disability. And you're not holding someone just because they have a mental disorder. You're holding them because this mental disorder is putting them in harm's way. Okay, let's keep talking a little bit about 5150. This is only for adults, and this is California Welfare and Institutions Code. Just to remember, 5150 does not fall under Tarasoff, and it's not required to 5150 someone, but it could be malpractice, serious malpractice issue if you don't. Determining danger to others. On the test, they might want to know how, when you have to evaluate, is this person really a danger? Think about perps. Do they have past behavior? Are they drinking? Can they think cognitively? Did some major stressor happen? And do they have a plan for what they're going to do? Remembering that a weapon in the house and danger goes up dramatically. So key to grave disability is that if any adult shows up and says, I'm willing to take care of them, then you can immediately waive that it's grave disability. The 14-day hold is what comes after your initial 72-hour hold. And what changes is, again, you have the open, you can now have a writ of habeas corpus. This is called a certification, and it has to be signed by 2 people. It can be reviewed. And that must be within 4 days of probable cause hearing. So you can challenge it. And this is to try to protect involuntary, not involuntary, but kind of unlawful imprisonment. So the third part is post-certification. And if it's suicide, it turns into a 5260. And this is another 14 days. But after that, you have to release them. That's the kind of last stop. With grave disability, you've got 30, you can get 30 more days now, and now you need to either initiate proceedings to find a conservator or something like that, but that's generally what's happening at that point. You can't keep holding them unless those proceedings are in process for the conservator. And serious danger, now here you can just, the 5300 can get reinstated over and over again until they're not a threat anymore. This can be put in place if they've continued to demonstrate danger while they're in custody, if they, in some way, whether it's through a threat, whether it's actually harming people or attempting harm. So what is conservatorship? It's anyone that the court appoints. And somebody who's going to take care of someone who is gravely disabled is the result of mental disorder or chronic alcoholism. This can be 30 days, short-term or long-term, for renewable 1-year periods. When you involuntarily commit a minor, it is not a 5150, in fact. This is actually a 5585.5. You must, though there is exception, call the parents and get authorization from them. This is really primarily the case, but of course there's an exception, which is when, as a result of a mental disorder, they're a danger to themselves, others, or gravely disabled, and that authorization is not available, you can't get a hold of them, for example, then someone designated can bring them in for treatment. Meanwhile, you need to keep trying to get in touch with them. So the facility should be trying to get in touch with them. So that would be the case with the 5585.5, especially for, non-emancipated minors, of course. Reporting and committing questions on the exam. As soon as you see that there's somebody who's dangerous, you're starting to get into, do I report or do I commit? So if there's abuse or danger, you need to start thinking, okay, is this a requirement or a possibility? Is this terrace off or is it a 1024? Suicide, as soon as you 5150 someone, you open the 1024 door, which is because you broke confidentiality to protect someone. Okay, we're going to talk about reporting abuse. We all know the general fact that elder and child abuse are mandated reports and that therapists are mandated reporters. Okay, let's talk about child abuse reporting. We need to know about filing reports, who to file them to, what happens when multiple people heard about the abuse, and what are things that are required to be reported, and what are things that might be reported, and also knowing what can happen if you fail to do so. So what are the reporting requirements? Well, we have California law, and specifically with California law, you need to submit a written report within 36 hours, report it to the appropriate people. One person can report if there's a team that knows. And this doesn't matter if you're emancipated or not. The key with mandated reporting is if you have a reasonable suspicion, you have to report it. It doesn't matter if it's hearsay. The question is, using your faculties, is this reasonable to think that something's really happening here? There is a number of kinds of abuse to be aware of. First, of course, is physical abuse. And this is clear that it's something that's purposely inflicted harm, ruling out mutual phrase among minors. Sexual abuse, this could be either assault or exploitation. So obviously anything like rape or incest, that is always reportable, no question, and must be reported. Lewd and lascivious means that someone's doing something to gratify their sexual desires with a child, and that could be anything odd that they might do. Sexual exploitation is pornography and prostitution. Neglect, severe neglect, there's severe and general neglect. Severe is actual, like, physical needs are not being met. They're in danger in terms of shelter and malnutrition. General is more, they're not providing adequate food and supervision and stuff, but there's not physical injury yet. You also want to know about willful cruelty or unjustifiable punishment. That is a mandated report, as opposed to emotional abuse, which is an optional report. So, yes. And finally, there's unlawful corporal punishment. If you're willfully inflicting harm and leaving bruises and such, that is unlawful corporal punishment. What else to know about California law? There is a neglect code and an abuse and neglect code, and that has what we just discussed in it. Now there's also a separate code that is the emotional abuse, and this is a may report, but it's up to you. So, law and ethics with minors. Knowing a little bit more about lewd and lascivious, this is actually mandated. And if anything basically if anything creepy happens with a minor and the person is 10 years older than them, it's mandated. There cannot be full sexual relationships with anyone above 21. Period. People that drink cannot do anything with people under 18. Cannot have a full sexual relationship with anyone under 18. And finally, sexting actually is a mandated report, so just know that. Legality and mandated reportings are not one-to-one. So just know also about the two laws in terms of being under 16, whatever those are. So child abuse, if you want to report physical violence, you're not supposed to report spanking on the butt. You are supposed to report using implements and bruising and such. Domestic violence can be categorized as emotional abuse. So you're not reporting the domestic violence, you're reporting emotional abuse to the child that is resulting. And this is actually mandated. So that's part of why I'm a little confused here, but that is part of why they put emotional abuse into the code to prevent kids from having to witness domestic violence. So sexual versus emotional abuse. Sexual abuse is always mandated. Okay, so watching domestic violence is in fact a mandated report. Okay, so to be clear, it is mandated. Emotional abuse, however, is when it's, I guess if you think it's abuse, then I think you are mandated to report it, but it's subjective here. So there's not an objective rule. You decide if it's a reasonable suspicion. And now, what about consensual sexual intercourse? Basically, if a kid's under 14 and the other's above 14, this is a report, period. You do not have to report if they're both under 14, or if the minor's 14 or 15 and the partner's no more than 10 years older than the minor. So that's a little contradictory of this chart, which says that it's a mandatory report if a 14-year-old is having sex with a 21-year-old. So I guess, okay, so maybe that is sexual acts, but once it's full intercourse, 21. Okay. And then the 16 and 17-year-olds, this is not mandated, it's subjective decision. So 16 and 17-year-olds is the 10-year rule, but you decide if it's abuse. Sharing confidential information. We kind of talked about confidentiality before, and that there's this idea of general, that if it's for the purpose of providing health care, you actually don't need authorization. So you can exchange information with your personnel team, and this is still confidential in court. So testimony is not what's permissible from someone else who heard about your client. Okay, let's talk about immunity for making reports. Mandated reporters have immunity, both criminal and civil. If you make it with reckless disregard of the truth, then you don't, but other than that, you do. Now, what about liability? So there's a lot of pressure, and in a good way, I believe, to make these reports as a mandated reporter, because you can face criminal penalties if you fail to report child abuse. It may have civil liability and disciplinary action as well. However, the penal code we're going to talk about for a second is that if you fail to report, you just want to think misdemeanor, 6 months, $1,000. If you fail to report and there is death or bodily injury, then we're talking up to a year and up to $5,000. We are legally required to tell people when we file reports. Ideally, you have them do it yourself, and there's always these safety exceptions. So if you think that telling them is going to cause more violence, you do not need to. What about adults who are abused as children? The key here is unless the victim's still under 18, this is not a mandated reporter situation. But if you have reasonable suspicion that this person's still out there victimizing children, well, there you go. Doesn't matter if it's hearsay or what. As soon as you think there's a reasonable suspicion that's coming up in your professional relationship, you must file a report. As a mandated reporter, you are still given protection if you make reports outside of your professional role, though it's not mandated. If you see child abuse in the grocery store, you're not in a mandated situation, but you are still protected if you choose to do so. You can always call CPS. Cultural issues. Basically, we can't use cultural issues as a means to get out of reporting things. So if someone says, oh, we beat our children at the age of 13 to initiate them, well, then you can let them know, hey, I mean, if you want to let them know, hey, you respect that, it's a cultural thing, but I have to report it. You do need to report it, though. Third-party information. This is what I was saying about whether you're in your professional capacity or not. Any reasonable suspicion in professional capacity, report, up to you if you're not in professional role. Okay, elder and dependent abuse, adult abuse reporting. We've got some reporting requirements here and responsibilities. You need to know when and how. You need to know who's authorized to receive the report. And you're not required to file the report if the dependent has experienced an act that constitutes reportable abuse, but there's no evidence, they have dementia, and they're subject to court-ordered conservatorship. So it's up to you to decide if there's reasonable belief, but just because the elderly person says it is not make it mandated. Whereas if a kid does, there's a little less wiggle room there. You only need to report spousal abuse if there is the age differential. Okay, so when and how. If it's severe, you need to make it within 2 hours. Call law and call the local ombudsperson within a day. So, who is an elder? That's someone in California 65 plus. Dependents are anyone who don't have full capacity, and they are admitted as an inpatient to a 24-hour health facility. Okay, I'm going to try to make the reporting of elder abuse as simple as possible. First of all, you need to take into account the location and the type, and then you decide who to report it to and how long you have to do so. So there's long-term care facilities, state mental health facilities, and then other. So with long-term care, here's the different types of abuse that can occur. Physical abuse with body injury, physical abuse without body injury, and then physical abuse without that's believed to be caused by actually a resident with dementia. Fourth, of course, there's abuse that's other than physical abuse. When we're talking about physical abuse, you need to call law enforcement immediately and then follow up in writing to the ombudsperson, the licensing agency, and the law. So long-term care physical abuse, you're ASAP calling the police, and then you're writing all three concerned parties. With serious bodily injury, you need to write reports within 2 hours. Without serious bodily injury, you have 24 hours. Now, when it's caused by a resident with dementia, you need to call immediately or within 2, really as soon as possible, but your writing doesn't have to happen for 24 hours. So that's kind of a split between the first scenarios. Now, when we're talking about other than physical abuse, you need to call and write to the ombudsperson and the law enforcement, but there's not a time stipulated on this. So I guess they don't consider it as dangerous. Now let's talk about state mental health. So there's kind of abuse and neglect that's causing injury, that's sexual in nature, broken bones, and then there's any other type of abuse or neglect. With the more severe abuse and neglect, you need to call the investigators of the state and the law enforcement within 2 hours. If it's other types, you get to choose. You call one or the other, but you should be calling someone immediately in both cases. And finally, any other location without any other kind of abuse, you need to call Adult Protective Services or the police immediately, and then you need to follow that up with a written report within 2 days. So that's the long and short of it. Okay, so what are the types of abuse that you can face as an elder or dependent? You've got physical. That's pretty obvious what that could be, but it can also be like sexual assaults, lewd, lascivious acts, etc. Also using chemical restraint or medication for punishment beyond what the physician wanted. So you can imagine kids like drugging their parents to keep them calm or something. Abandonment is just leaving them without care when they're not able to, when a reasonable person wouldn't leave them there. Abduction is you're removing them from California when they don't have the capacity to consent to that. Isolation is when you deliberately prevent them from receiving phone calls and visitors, and you isolate them from other people. Now, they may not constitute isolation if they're performed in accord with instructions from a physician or if there's a danger to the person's safety or property. Financial abuse happens with elders, and that's when you take the property of an elder wrongfully or defraud them. Neglect is when you're responsible and they're in your custody, and you are not exercising the same degree of care another reasonable person would. So you'll notice here in elder abuse, they're talking about what reasonable people would do a lot. And this can relate to hygiene and then all those basic necessities like food, clothing, shelter. And thirdly, it can be protecting them from hazards or malnutrition. So neglect also includes self-neglect. That's the result of impaired functioning in substance abuse. Okay, so those are the types of abuse that has to be reported. Now, reporting that's allowed is when you reasonably suspect that their emotional well-being is endangered. But you don't have to make that report. It's up to you. Okay, so we'll talk about immunity and liability again. Mandated reporters are not civilly or criminally liable for making a report that is authorized by law. So that's pretty good, unless it's proven that you knew it was false, which is ridiculous. Why would you do that? But people are crazy, so therapists and otherwise. Liability, this is the same as with kids. You can face criminal penalties if you knew of abuse that you did not report. Misdemeanor punishable 6 months, $1,000. And then if it results in injury, you've got a year and $5,000. Next up is sexual misconduct. Okay, so sexual misconduct. We're going to talk about laws that pertain to sexual relationships with clients. In addition to laws that pertain, we'll talk about the ethical standards and also what happens when it's a colleague and a client and it's not you as a therapist, psychologist, know of it. So let's start with the laws. We're going to talk about criminal liability, civil liability, and the disciplinary action by the board. Criminal liability says if you engage in an act of sexual intercourse, sodomy, oral copulation, or sexual contact with a former patient or client when it is terminated when it's terminated for the purpose of engaging in those acts, this is guilty of sexual exploitation. So, in no instance shall consent of the patient or client be a defense. So this is a criminal act. Criminal. Okay, what about civil liability? You can also be have civil liability. The patient can say that you caused injury to them, and this could be during the period they saw you, within 2 years following therapy, or by means of deception. Finally, this is defined as unprofessional conduct by the board. And disciplinary action is specified, and if they find that there was sexual contact within 2 years, they will revoke your license, and that shall not be stayed by the administrative law judge, whatever that means. I don't actually know. So, criminal liability, depending on the number of sexual acts, we're talking about different levels of crime. If it's one sexual act, we're in the misdemeanor category. If it's 3, it's a felony. And 2 sexual acts is called a wobbler, so that means the court can choose. What are the standards that pertain ethically to sexual relations? Well, first of all, you can't do it with current clients. So that's standard 1005, and that's pretty straightforward. Former clients, not for 2 years, only under the most unusual circumstances. And if it does happen, need to really demonstrate you need to bear the burden of demonstrating that there's no exploitation. And that means addressing a lot of different factors, like the nature of the therapy, time passed, circumstances of termination, client history, their mental status, how likely is it to adversely impact them, and did the therapist at any point during the course of therapy suggest that it could happen post-termination? That's a big no-no. We are also prohibited from engaging in intimacies with people we know are close to the client. And you can't quit seeing your client to circumvent that. So you can see that's there. 1007, you cannot provide therapy to a formal sexual partner, period. No exceptions. That's it. Done. And finally, students and supervisees. If you have evaluative authority, that's not appropriate. So there is not a 2-year rule here, however. But in that relationship is still considered an unethical multiple relationship and could be a real problem. However, it changes down the road. So if you learn that a colleague has had sexual relationships with a therapy client, you are ethically and legally obligated to take steps to protect them. When a client reports that, so you know that you're required to give them the brochure, professional therapy never includes sex, if your client tells you. And of course, if it's a client was a minor, then if that therapist is still seeing minors, then you need to make the report. However, it's similar to any child abuse report. If they were an adult, if you know that therapist isn't practicing anymore, then it's not a report. When a colleague discloses, so this is when it gets really tricky. What if a colleague says, hey, I'm having sex with a client? You need to think really carefully. This is not something you can resolve informally, but you can't file a complaint if it would violate the client's confidentiality, because that takes precedence. Okay, we'll discuss forensic issues. Key here is to know about malpractice. So what can happen to you in the courtroom, subpoenas, and psychologists in the courtroom. The specialty guidelines for forensic psychology help clarify some of our roles and responsibilities in this field. When we are in the courtroom, this can relate to a number of things, including the insanity defense, expert witnesses, etc. So let's define forensic psychology to start. As in the specialty guidelines, this is referring to the professional practice working within any subdiscipline of psychology when they use that knowledge to assist in law. Expert versus fact. If you're asked to testify as an expert witness, this means that the court has decided you have special training or experience relevant, and the court is the one that designates you as an expert. The fact witness is saying facts. What did you see? What did you hear? What did you observe? You cannot here offer an opinion. However, you can say their diagnosis was this that I gave them, because that's more of a fact. You can only provide that information about your client with consent or court order, however. And why is that? Well, that's because of privilege. Testimonial privilege. So remembering that, and we'll talk more about this, but privilege is a legal term, and the client, in pretty much all cases, is the holder of privilege. The therapist may waive it on their behalf, but only with permission from them. Informed consent. Okay. Unless court ordered, we must obtain informed consent before proceeding with a forensic examination. If they won't proceed, you can postpone it or have them contact their client. You can't force someone to, proceed if they don't want to, but, there is no confidentiality there. But you are obligated to inform them of this as soon as possible. They need to know the parameters. If there is, so you can conduct the examination over the objection of, but if they still don't want to do it, tell them to contact their attorney, and then you will notify the retaining party. So that's important to know, is you are responsible for notifying the retaining party. And when a person lacks that capacity, well, I think this is pretty obvious. The person who's legally authorized may do so for them. And then, as always, you're seeking assent. The insanity defense. The legal conditions for an insanity defense are specified in the penal code. So you can only use this defense when there's a preponderance of evidence that they were incapable of knowing and understanding what was happening at the time of the offense. So that's important. This is not about, are they insane now? It's when they committed the crime. So it could be a seizure, it can't be just a seizure disorder or a personality disorder, or like having that. It has to really be something very specific to that moment. Not competent to stand trial is different than the insanity defense, because this is when you're determining if that person can even be in a trial, because it's to stand trial, you must have an ability to understand what's happening. If you can't comprehend, that's not fair. And so the trial will go on once the person is competent, but until then, no. And you can use the mini mental status or a mental status exam to help. You don't decide, but you give them your assessment. The subpoena is a really important thing to know about. What is that? Well, it's a document that gets delivered to you saying, we need you to give testimony, and a subpoena jucis tecum requires you to bring a specific document. So how do you respond? Well, the first step is it legally valid? Often they're not delivered legally, so you want to check out that it was legally valid before you do anything. So you will contact the client and or the client's attorney to figure that out. Next, you're going to want to negotiate with the requester, try to file a motion to quash it if you can. So at first, let's say that didn't work out, then you do need to show up in court. But you can assert privilege on the client's behalf. And until a court orders you to release information, you don't have to. But once the court orders you, you're into contempt of court if you don't comply. So privilege, the psychologist is never the holder of privilege. You are claiming it on behalf. And don't acknowledge that the person's your client when they deliver the subpoena, because that's a breach of confidentiality. So this is where we get into subpoenas and court orders when we talk about the holder of privilege. With a subpoena, a therapist can invoke privilege on the client's behalf. They must come to the court if they are subpoenaed, and they need to let the client know they had it. And unless there's permission to release it, they do not give over that information. However, with a court order, indeed, you are required to give that. And this won't happen ordinarily unless the judge has really determined that an exception applies after reviewing materials. So let's compare court-ordered evaluation and court-ordered therapy, because there's differences in terms of confidentiality. Court-ordered evaluation is just an exception to confidentiality. The results are intended to be reported to the court, so there is none if the court ordered an evaluation. But this does need to be explained to the defendant beforehand. That is ethically required. Court-ordered therapy, it depends. So it's usually offered as an alternative to jail. So a lot of times there is already an arrangement where their information will be released, and they just need to have informed consent about that. And they can always go to jail if they don't want to. But there are some exceptions with treatment settings connected with the court. So if the client seeks the therapist program, sometimes there is confidentiality and they need consent. But there are treatment programs connected to courts where it's kind of established already, and just the patient needs to know that. So malpractice is the direct dereliction of duty. Talk a little more about that. So the conditions are these 4 Ds. You must have had a professional relationship where there was a duty of care legally. There's a demonstrable standard of care that's been breached. This is where the ethics code ends up kind of melding with the law, because they can say, look, according to the psychologist's ethics code, you didn't do X, Y, Z. Did the person actually suffer injury? And then was the injury actually the result of the dereliction of duty? Well, what are the types of compensation you can get? Award, nominal, and punitive. Reward is trying to, restore balance in the universe. Nominal, something happened, okay, yeah, but not much we can do about it. Not much way to translate it. And then punitive is what you did was bad, and we're punishing you. How can you reduce your risk from malpractice? Experts say that being familiar with law and ethics is the most helpful thing to do, and maybe even above that is maintaining, in line with that, very well-organized records. And another suggestion is to get coverage. Custody issues. Just because you have timeshare with a kid, you don't necessarily have legal rights. And then vice versa is true. Just because you do not maintain physical custody, but you do still have legal custody, then you do maintain your right. So really, one is not the other. You always refuse to offer an opinion for one parent. Yeah, that's that. Laws regulating. Okay, so now we're getting into the really fun and boring stuff. Okay, so let's see if we can make this fun. This is the field we're talking about. Here I am studying so hard to be a psychologist, and what is this thing that you have to go through so many hoops to get to, and why? So we have the Board of Psychology, and these are the folks that give out these licenses. What is their goal? To protect the public, and this is accomplished by regulating the providers of psychological services. They are in charge of regulating licensed psychologists, psychological assistants, and registered psychologists. So these are their responsibilities. Let's talk about licensed psychologists. Who are these people? And how do we know that they deserve this supposed license and are trustworthy? Well, first of all, they have a doctorate degree in some form of psychology. And clearly that, means they've gotten many, many years of knowledge and coursework. And that included substance abuse, sexuality, child abuse, spousal abuse, and aging and long-term care. So substance abuse is a whole quarter, but these other ones are like workshops. So sexuality, 10 hours, child abuse, 7, and aging is also 10. And then the spousal abuse can just be a 2-year. It used to be 2 years, but now it's 15 hours. Okay, so yeah, that's actually a lot. Okay, so here they have their degree in particular coursework. That means that they can fulfill their ethical requirements. They also need to have experience. You don't get your license until you have 3,000 hours of experience, and that needs to occur within a 30-month period. So you have 2.5 years to get those. You can't just extend it over the course of 10 years. They also need to have passed the EPPP and the CPSE. And this really means that they've had to verse themselves in the ethical, not only the knowledge of the field, but the ethical standards. So they actually know what their license means. If they've already been licensed 5 years in another state, instead of taking the CPSE, they just take the law and ethics one because it's assumed they know what they're doing with the psychology part. And the California board doesn't need to worry about that part. They just need to catch you up with our state. What about psychological assistants? These are folks with a master's degree at minimum, and they can provide services, but they have to be supervised either by a licensed psychologist or a board-certified psychiatrist who can only supervise up to 750 hours. They cannot do all of those hours. Also, just important to know in terms of going back to psychologists briefly, you cannot practice psychology or represent yourself as a psychologist without a license, unless it's otherwise provided in another provision. Folks who are licensed in another state, this is interesting. They can provide services in this state for a period not to exceed 30 days in any calendar year. So you could come here for a month and offer therapy. You just have to leave. You can't set up a long-term practice. which also means that if you're on vacation or, there's all sorts of laws, but it gives you a little leeway. However, let's say you move and you're licensed in another state and you want to become licensed in California, you do need to take the CPLEE, Law and Ethics. That, of course, everyone has to take that. If you've been licensed for 5 years elsewhere, like in the States or Canada, then, as soon as you take that exam and put in your application, you can actually start practicing without your license once you submit the application. And that has a period of 180 days, or once you leave. Supervised professional experience. Okay, so we talked about, so now we're going back again to the psychological assistants. We talked about their hours, 30 months. If both years of the experience are completed postdoctorally, then you have a 60-month period. So the idea being 1,500 has to happen within each, with 2.5 years each. So you basically overall have 5 years. Pre-doctoral. Okay. There's 4 ways you can do this. A formal placement, APA, or CAPIC. You can be an employee in an exempt setting. You could be a psych assistant with the board, or you could be pursuant to a Department of Mental Health waiver. Postdoctoral is similar. You could be in an APIC program. Not CAPIC this time, that's just pre-doc. You can be a registered psychologist, which we'll talk about a little bit more. Again, the employee of an exempt setting. Again, the psych assistant. And again, the Department of Mental Health waiver. So what are the requirements for this supervised professional experience? Well, there are requirements for it. And just briefly, the registered psychologist, that means that you have your doctorate degree. You've already had those 1,500 pre-doc because it's only a postdoc thing. And this is when you're working at a community agency that gets 25% of funding from government sources. You can do this for the 2.5 years, but this isn't something you can renew. This really is meant to be your postdoc, not a forever situation. Supervised professional experience can be obtained in many or several ways, which we've explained. So it can be the internships, the exempts, the psych assistant. So all of those different things we named are ways that you can get it. What about the supervisor, though? The supervisor needs to have 6 hours of coursework every 2 years. And when for your hours to actually count, we've all been through this. Minimum of 10% of the total time worked each week, you must be supervised. 1 hour is direct face-to-face weekly, and you can only count 44 a week toward the SPE. Also, a requirement that you maintain a weekly written log with all sorts of information that needs to be signed by the supervisor. The primary supervisor has to be employed in the same work training and available 100% of the time. And that could be, by pager, but they need to be on call for you. They have to have a plan to protect the client. You can't get these hours if you're working under your social work degree. You can't get these hours if a supervisor is receiving payment from you. That's not supervised professional experience. And trainees must have no proprietary interest in the business. So let's move on to the next slide now that we're kind of talking a little bit more about supervision. Okay, so finally, with the supervised professional experience, before you start it, the supervisor and trainee have to sign an agreement, a supervision agreement with all sorts of good stuff included in it. Supervisees are responsible for maintaining the log, as we said, and all sorts of good stuff has to be on the log as well. So what about these primary supervisors? So we know they need to have the 6 hours of training once every 2 years. They must be licensed or board certified. It has to be free from any formal disciplinary action, and they have to let the supervisee know if something changes. They have disciplinary action that would affect their ability to supervise. They need to be competent and have all of the relevant experience. The 6 hours of coursework. They are responsible for ensuring the trainee complies with all the record keeping and everything like that's in the ethics code. Granted, both can be held responsible in a way, but really it's ultimately the supervisor's responsibility, according to the board. Primary supervisors are responsible for the welfare and the performance and conduct of the trainees. They ensure that clients receive services. They ensure that clients know that the trainee is not licensed, that they'll have access to records and be supervising. And also any fees have to be paid to either the employer or the supervisor. A few more things. We already went over these, but you can't have any kind of business, other multiple relationships that will compromise. You cannot supervise a trainee that's been a psychotherapy client. You must not exploit trainees or engage in sexual relationships or other sexual contact. You have to review the pamphlet. Professional therapy never includes sex. And you have to monitor the supervision performance of all the delegated supervisors. Okay. Right, so, yeah, I guess signed agreement, same work setting, monitor supervisee, ensure crisis plan, make sure supervisees comply, make sure that the clients are notified about records, unlicensed, how to get in touch with them, share that pamphlet about professional therapy and sex, you can't get paid for it, psych assistants can't rent the space from you. The fees are paid to the supervisor. The supervisees don't have proprietary interest. You can't work under another license. Delegated supervisors are allowed. And finally, they cannot be related to supervisees, engage in sexual contact, or someone who was a therapy patient. Finally, let me just say the delegated supervisors. And then we will move on to a little bit of something else. These are supervisors that were delegated by the primary. They don't have to be psychologists. They can be social workers, clinical social workers. But that 1 hour face-to-face is always going to continue to be the primary's responsibility. And again, the delegated supervisor has to be employed by that organization. Even if that's what they're employed to do, still an employment though. Okay. So Board of Psychology actions. When the board determines that a consumer complaint is valid, there's a few things that can happen. Things that are non-disciplinary, or they can be found guilty of unprofessional conduct. If it's non-disciplinary, you might just get a letter of warning. The citations and fines, while they're non-disciplinary, they are available to the public. It's the more serious things that are disciplinary actions. And a disciplinary action is like a letter of reprimand, probation, suspension, surrender, or revocation. Okay, so non-disciplinary and disciplinary. The board can also deny applications for licensure and suspend, revoke, and that's all related to the unprofessional conduct thing. So you can commit crimes as a therapist, but if it's related to your duties as a psychologist, then that becomes a problem with the board. If a substance is impairing your ability to work, if you're misrepresenting your license, if you're impersonating another person or using deceit to pass exams, if you're paying for referrals, if you're making misleading statements about your services, willful unauthorized communication of confidential information, if you're being grossly negligent, aiding or abetting in unlawful practice, you can't help anyone else practice unlawfully. If you have had probation in another state, if you're committing fraud, any sexual abuse, sexual misconduct is certainly disciplinary. And if you're outside your area of competence, willful failure to provide verification of an applicant's supervised experience to the board is unprofessional conduct, and repeated acts of negligence. Woo-wee. You must also, once you have that golden license, you must continue to educate yourself, which I think is actually a really nice thing. You can renew your license every 2 years. It expires on the last day of the licensee's birth month. So happy birthday, you need to worry about some paperwork. It can be renewed within 3 years of expiration, but after 3 years, you have to apply for a new license. You can put it in an inactive status if you're not practicing. With out-of-state licenses, like we said before, you've got 30 days in California a year, and after submitting your application, you have 180 days to practice. So that might apply for someone who moved here for a job, a licensed psychologist who moved for a job. For example, so what about these continuing education requirements? 36 hours every cycle. 75% can be independent learning, like on the internet or something. Training has to be there has to be something that happens in the law of ethics every renewal cycle, but there's not a certain number of hours of that. One-time renewal requirement of coursework in spousal partner abuse, minimum of 1 hour. This actually does not apply to anyone currently, really, but that people who were licensed before 2004 at some point had to do that 1 extra hour. One-time renewal requirement of coursing in they also need to update themselves on that aging long-term 3-hour care, because in 2004 they added those. Continuing education qualified courses, so they're courses that the APA or CPA or CME approve. And supervisors, 6 of those hours, of course, have to be the supervision coursework every 2 years. Okay. That is pretty much everything there. Yeah, law and ethics, the prior to 2004 folks have to update themselves on spousal abuse and the aging long-term care. And that's really the gist of it. We're going to go to the last section now, and those are ethical violations and complaints. So here we've got some white men often reviewing things. I'm sure they're very nice fellows. Okay, so the ethics committee and ethics complaints, we'll talk about that, and we'll talk about ethical violations by colleagues. The first standard of the ethics code says, within 106, is that as a psychologist, you are required to cooperate with the ethics committee. any affiliated state, in fact. If you fail to cooperate, that is in itself an ethics violation. If you're a member of the APA, it can be handled by the ethics committee or the licensing board or the courts. Violations of non-members are not within APA's jurisdiction, but can be for others. Upon conclusion of an investigation of a complaint, the ethics committee will dismiss the case or recommend one of the following actions. You can do reprimand, censure, expulsion, stipulated resignation, are the different outcomes. So reprimand, that's like something, yeah, it was an ethics violation, but didn't really cause too much harm to the profession or another person. So that's like not putting your license number in your business card, probably. Censure is if there's a violation that was of a kind that really was likely to cause harm, but not substantial. And it didn't kind of hurt there wasn't a gravity to it hurting the profession to warrant something more severe. So maybe you had a client you didn't like and you didn't do pre-termination counseling or something like that. Certainly could have caused harm. So it's a violation, but you didn't hurt the whole profession in any sort of major way, and the person is okay. But expulsion, however, this is something that could cause substantial harm to another person and requires gravity. Finally, a stipulated resignation is something that can be offered if they find that the respondent, yes, they did commit a violation, and failed to show good cause why they should not be expelled, contingent on execution of an acceptable affidavit and approval by the board of directors. So, non-disciplinary actions for minor violations remain confidential, except for the citation and fine. And so what would those be? Mediation, educational letter of warning, education review, citation, fine. Okay, so the citation, fine, public. Now the disciplinary actions. Let's talk a little bit more about what that actually looks like. These, if they're more serious, they are referred as well for formal investigation. If there's support for whatever allegations were made, the board will submit themselves the case to the Attorney General. What kinds of disciplinary actions does the board itself take? A letter of reprimand for minor things, no harm happened. A two-step agreement for minor violations could happen, so you need to fix your business card or what have you. You could, and then if there's some real negligence, that's when you have more serious things that happen, like probation, revocation stayed, such things. What about suspension? This is when you cannot practice. For example, you were convicted of a felony, or you need to immediately suspend your practice. Surrender of license, the licensee just says, you know what, I'm out. They don't want to complete the whole hearing, so they can just surrender it. Revocation, though, is when the license is actually lost, and that guilty of sexual misconduct, you can see that would happen. What is your recourse? Well, you can petition for reinstatement or modification of the probation. At least 3 years for reinstatement of a license, revoked, suspended, or surrendered. At least 2 years for early termination of probation or of 3 years or more. And finally, at least 1 year for early termination of probation of less than 3 years. So, yeah, you can say, hey, board, please, I've made amends. Please modify this. If, the person's, you have to wait. So basically it's saying, if it was revoked, you need to wait 3 years before it can even be considered. If you were, if it was early termination of probation of 3 years or more, then you still have 2 years before you can modify that. Then 1 year for early. Okay. So time frame. Accusations must be filed within 3 years from the date the board discovers the alleged act, or within 7 years from the date the act occurred, whichever occurs first.